The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate and inform and help you because the law matters. Understand the law better, and you're in a better position to decide how to help or protect yourself, your family, and your business. We'll be providing resources and information that will help you determine perhaps whether you might want to handle some issues yourself. If you do decide to connect with outside counsel, you'll be better prepared, and as a result, so will the professionals you select. Either way, our hope is for you to have an opportunity to save time, money, and of course, achieve the best possible outcome. We welcome and thank from the Bazar and Associates law firm, David Bazar.
Thank you.
So in the past, David, we've been talking about personal injury. So today we can discuss the settlement aspects of it, and I understand there are things like negotiations that happen before and during litigation, and then sometimes afterwards, and there's mediation, and there's arbitration. And most recently, I even read that some people are really considering and are able to consider self-representation. So if you would, help us with that first. My reading said, gee, some people could handle issues themselves, decide to negotiate some issues themselves, as long as they consider the extent of their injury, how severely they were injured, and if not, perhaps they could, and also if the case was clear-cut. Is it ever clear-cut? What would you have to say about that, David?
So we were covering slip and falls last time, but personal injury really is personal injury, whether it's from an auto accident, a slip and fall, or someone's negligence that causes you an injury in some form or fashion. So once you've been injured and now you're talking about how do we settle the claim for the injury, there's a lot of components that go into that. And as you're saying, if someone's trying to do this as a self-represented person and they say to themselves or others, well, I'm a really good negotiator, I can do this. Well, you can be a really good negotiator, but if you don't know what it is you're negotiating and what the values are that the insurance company puts on a case, what the values are that should be put on a case, what a jury might do with a case, then you're really not in a position to be able to negotiate a settlement that might be fair for you. And I can give you a number of examples where people have come to me. Just, I want to get a second opinion or an opinion. My daughter was in a car accident. She's fine. She just had a big cut across her head, and there's a scar, and they show me a picture of the scar. And I remember in one particular instance where this happened, I think the offer was like $5,000 or something. Is that fair? Does that look reasonable for everything my daughter's been through? And looking at it, it wasn't even close. And we ended up taking the case, putting it in suit, and at an arbitration, I think the case settled for like $45,000, which was what that case was worth given the scar, the medical treatment, and the bills and everything that went into evaluating what the damages that that girl suffered are. And so, can you do it? Yeah. Should you do it? Almost never, because I can almost guarantee you that, and remember, you're not paying an attorney an hourly basis or out of pocket or anything. So once you've agreed upon a fee, which is usually a third, and once all the other expenses are paid back, you almost always end up with more money in your pocket.
And not surprisingly, David, as we've talked about personal injury before, and we see those commercials that say the lawyers are out to help you, and of course they make a lot of money, and of course the counter to that was, gee, you can save that whole third or more, plus the time and the energy, you can do it yourself if it is a minor issue. Now you described a cut, which could or couldn't be minor, but the other side of that, regardless of the extent of the damages, is the case clear-cut? I would imagine that it would signal to anyone who is on the paying outside of it, they would be likely to say, if I'm just dealing with an individual here, I can certainly raise enough issues that will make them either bring it down or certainly consider that they shouldn't be doing this, because you know they're going to undercut whatever someone proffers as a suggestion.
Sure, and that's what they do. So when you say, is it clear cut? Well, what you're saying is liability clear and certain? So in the particular case I was describing, the young lady was a passenger in a car. She hadn't done anything to cause the accident.
Oh, okay.
So it was clear cut. Mm-hmm. Could they have argued something? Maybe, but there really wasn't any liability issues. So it was was really arguing about what the value of the scar was. So in talking about how you evaluate damages, and I think we may have touched on this a little bit last time, we didn't talk about scarring as an element of damages last time. And so what the case law says is that you look at how that scar affects that person. So the testimony that the young lady gave was that every day she wakes up, and as she got older, she started putting on makeup, and she sees it in the mirror, and it affects her every day. So a scar that's on that young lady's face that she sees every day as she's getting washed up and brushing her teeth and putting on makeup bothered her. And it bothered her because if she didn't have makeup on it, friends would say, "Ooh, what happened to you?" So you have to look at each of these things on an individual basis. And in this particular case, that scar was worth much more than the $5,000 that had been offered to settle the case because it affected this young lady every day. Now, if that same scar had been on some person, let's say some 45-year-old man's leg that he never really looks at and doesn't care about, maybe that was the right number. So lawyers who deal with these things understand what the aspects of valuing something like that are and what the arguments you would make to an insurance company are, or to a jury or an arbitrator or a mediator. So can you handle it yourself? Yeah, but are you cheating yourself? Probably. Again, that case, I just will tell you that when they came in and they told me this was the offer and I knew it was way below what it should have been, I told them that I will not take a fee on the first, in that case, $5,000 that they had been offered because they already had that. They were going to get that. And I was confident enough to know I would get much more money for them, that I would just take my fee on the money over and above what they had already been offered.
Be in excess. So it makes sense that there are hard costs and soft costs, hard costs. Someone had to be stitched up, it took an x-ray. The medical bills are some of those hard costs. Seems to me that you were going after those softer costs, whatever kind of emotional damage or whatever else needed to be done. She had to buy some more makeup or maybe have other surgery so that she had cosmetic, I don't know what the extent of that was, but those soft issues certainly are things that it would seem to me a younger, inexperienced person or other than a lawyer wouldn't be able to assess. And even you, don't you actually go outside and have other people such as financial consultants help you at times to make sure you do right by your client?
Well, yeah, certainly it depends what kind of case it is. I handled a case once for a person who was severely injured. It was a quadriplegic injury, and in that particular case, we hired a person who does an evaluation of what the needs will be medically for that person going on into the future. We also hired somebody else to help us cost out what the future cost of those things would be. And then, of course, we have to reduce it to present value because today's dollar may be worth more than a dollar 30 years from now. But all of these factors go into it. In a wrongful death case, which when we handle those, there's a very specific statute that talks about how you value the economic value of somebody's life, which is really talking about wages into the future. We've hired economists from Brown to come in and testify in cases I've had before where they will look at someone. I'll give you an example. I had a young fellow who was in a program at the University of Rhode Island as a freshman. It was called the Talent Development Program, or TD program. And so this young fellow was just at the beginning of his professional career, which hadn't even started yet.
Sure.
So what was he going to do, and how can an economist come in and look at that and put a value on his lifetime of earnings? Well, in that case, what we did was we had the economist look at what the other family members did, what people coming out of this program have done in the past, and what the track that this young fellow was on before he was killed untimely. And as a result of looking at all those things, the economist was able to project this could be his lifetime earnings. Once you take those earnings and you reduce them to present value, this is what the value of that is today. And there's a number that's easily explainable to the jury. The jury was able to understand exactly what he was talking about. We took him through in plain English so that it matched up with what the statute required us to prove. And so that part of the damages were proved by an expert.
And I guess they'd have to consider if he's 20-something, he might have a lifespan of thus and such and do all of those multiplier. That expression, multiplier, does that have anything to do with a judge or, a jury's understanding of what could have been a punitive issue related to that? Is that part of the settlement too that you have to negotiate, or is
Okay.
that not?
So not really, but let's just talk about how juries work in some different aspects of what you're saying. So some people think there's a multiplier that you use. What are the out-of-pocket expenses, and multiply that by a certain number, and that's what your case is worth. That's not how it works.
Okay.
Doesn't work that way at all. So in that wrongful death case, we had the medical bills that the fellow incurred before he died. He didn't die right away, so there's that conscious pain and suffering period. All of those things are factors into what the value of the case is and how you measure damages. And then in that particular case, the multiplier or factor you were talking about was what the life expectancy is, because you have to take a look at this fellow's life expectancy, and more importantly in that case, his work life expectancy. And that's what the economist uses to figure out the future value of his lost wages or his lost earnings. And that is based on tables that are commonly used by economists that can be found online, actually. We always talk about, is there a resource online? You can look work life expectancy, life expectancy. You'll find tables that say a 23-year-old person of this male, female background, whatever it might be, you can put in some more details than that, has this statistical expectancy. So the economist uses that. The present value reduction is based on interest rates and what is a dollar today going to be worth 30 years from now, so that dollar 30 years from now can be reduced to a present value today. And those all have to be done within economic reasonableness. So an economist can justify what he's saying and using for the numbers.
So take us through this. I think we've pretty much dispelled, if someone's having even what seems to be a minor accident, they might want to think twice about self-representation. I think you covered that pretty carefully. So when you have someone come in and they say to you, we have an issue here, you have to build a case. Presumably the stronger the case, the more likely it is that you're going to benefit or have your client benefit. How do you go through putting that together so that you are more likely to settle it versus going the whole lengthy process? How does that work, David?
Well, first and foremost, you want to get the best experts that you can if it's a case that requires experts. Not every case requires an expert, although I'll take that back a little bit. Doctors are experts. And so you want to make sure your client is seeing the best doctor that they can see, because first of all, you want them to get better. But of course, those doctors who are experts, their reports have some credibility issues too, depending on whether this is a doctor the insurance company regularly sees, doesn't see, things like that. So that's one thing you need to get put in place right away. And we're really talking about damages right now. If there are liability issues, you want to be all over those liability issues as early as you can. I think I've talked before about a case where my client was injured when a RIPTA bus came out of a side street and he had to lay down a motorcycle. And what we were able to do with the police report help and the client's help was track down a witness to that accident and get his statement immediately, so that we had it locked in, we had his contact information, and if this case doesn't resolve down the road, we'll be able to contact him and bring him in and get that liability locked down. Because without that independent eyewitness, it's sort of he said, she said, because the RIPTA bus took off and wasn't at the scene. So unless, it's my client's word against RIPTA's bus driver's word that he was never there, how do you prove that case? We needed to get that witness right away. So whatever liability issues you can lock down right away, you want to do that. That does put you in a better position to try to resolve the case when you're just arguing about damages.
So you have this testimony that says to you, I guess we can tell that it wasn't my client's fault that this happened. When are you in the process likely to say, let's talk about what this is going to settle to be? Obviously, the person who is likely to pay out is the one who's holding the cards about whether or not they want to settle, whether they think they should, whether they should push you to go to court. How does that play out? Who makes that first move and who blinks first?
So here's how it usually works. We wait until our client has completed all of his or her medical treatment, make sure they're either fully recovered or reach maximum medical improvement, which is just another way of saying they're as good as they're going to get as a result of this accident. You get all your medical records, bills, reports, other documentation that you need to prove the value of your case, lost wage information, and you put it in a package that's nice and neat and easy for the adjuster at the insurance company to go through. They'll go through it, and hopefully, you talked about negotiation before a case is put into suit. You go back and forth and come to a number that's fair for your client, and you get the case settled. That doesn't happen all the time. I'm going to say it doesn't happen a lot of the time.
Okay.
A lot of time, you'll either talk to an adjuster and say, we're not getting close on this. Let's put it into, if it's an auto accident with a value of under $50,000, perhaps you'd say, put it in pre-suit arbitration, which is, let's just pick an arbitrator. Let's see if the arbitrator can get a number on it that we can both live with before we even have to put it into suit, and maybe that'll resolve it. Some cases just need to go right into suit because they're either worth more than $50,000 or you know that the adjuster is not going to bend, so the arbitration is going to be a bit of a waste of a time. So put it in suit and go forward from there. So that's the process of how you hope initially a case may be either negotiated and settled or moved along.
You mentioned arbitration. Is arbitration something that you both agree to do, but if you're not both happy, then you still have the option of going through to litigation, or is it?
Yeah, it depends. It depends. There's both binding
Yes.
Arbitration and non-binding arbitration. So pre-suit arbitration, court-annexed arbitration in Rhode Island, which is part of the process of a Superior Court case, both of those types of things are not binding. You can opt out, you can reject the award, and you can move on. You can agree to binding arbitration, which can either be high-low binding arbitration, which is there's a maximum that is going to be paid or a minimum, and anything in between, whatever the arbitrator sets would get paid. That is another form of arbitration that we use quite often. But usually those things come after the case is in suit, after you've gone through your discovery process, interrogatories, requests for production, whatever other documentation needs to be exchanged or provided, and then both sides have a decent idea of what they think the value is, so you might be in a better position to either go through a binding arbitration or a mediation.
How does the mediation happen? I know that you are a mediator, but we're speaking to you right now as you are the lawyer, not the mediator.
Right.
Is that something that a court would say you have to have this mediated versus going to trial? Where does that come into play, David?
So that'll depend on what court you're in as to whether it's required. In federal court, there's a mediation requirement, or actually, I should say, alternative dispute resolution requirement, ADR. In Rhode Island, we have court-annexed arbitration, which is required in most cases. There are some ways of opting out. The city of Providence sometimes will opt out, or the state of Rhode Island as a defendant can opt out. But most cases go through that court-annexed arbitration. Other forms of alternative dispute resolution are usually by agreement of the parties.
And how involved are the parties? You have someone who says, I think I need to have some compensation here, David. If it goes to arbitration or mediation, are they sitting in with you every step of the way, or just kept apprised of it afterwards?
Yeah, most cases, 99% as far as I'm concerned, the parties need to be present.
At all times?
All times. So mediation, what will happen is we'll have figured out what the value of our case is. And now, just remember, that value is sort of in the eye of the beholder. There's no, this is the number, that's it. It's usually a range. And so you explain how that is arrived at to your client beforehand. You explain the process to your client, which is that we're going to go to the mediator's office. We're going to sit in a room together. The mediator is going to explain the process. The attorneys will each give the mediator an opening statement, so to speak, as to what the case is about and how they've come to the figures they came to, if the arbitrator, a mediator wants to know about figures at that point in time. And then usually you'll break out into separate rooms, and the mediator will go back and forth, almost on what we used to call a shuttle diplomacy type of mission. And the mediator will explain to me and my client the strengths and weaknesses of our case as the other side sees it, and to the other side as we see it. The mediator will explain the value of settling a case as to opposed to going to trial and the uncertainty of what a jury might do. All of these things are things that I probably will have already told my client, but sometimes it's good for the client to hear it from a neutral person. And as we go back and forth, the bottom line is the defendant in the other room has to come up with enough money to make it worthwhile for my client and for me to walk away with a settlement as opposed to take our chances at trial.
And so the longer or the deeper, the farther you get into that process, is that more likely to increase your client's settlement? In other words, if you were just tossed a figure right up front, maybe it was very generous and wonderful and you settle right there, but isn't it more likely that the deeper you get into that, that more likely the defendant is going to realize that you have a strong case and is more likely to up the ante, so to speak? Is that generally the case or no?
Actually, it depends who's on the other side.
Okay.
So I've been doing this since 1983, and I generally know most of the defense attorneys, most of the insurance companies, and a lot of the adjusters, especially the local ones. So I can tell by just who's on the other side how this is usually going to play out. There are a lot of attorneys who know me, and in my cases know that they can just be right up front and reasonable, and we don't have to go through that whole long process necessarily. There are others who, no matter what, you're going through the process. So you just may as well strap in for a 1 or 2 day mediation and go through the process like you would have to do, as you said, to maximize your client's recovery. And the whole goal is to maximize your client's recovery. Certainly. So sometimes if you have a really good attorney on the other side and a really reasonable adjuster, and you can get this done for full value, or what, remember I told you about that range, something significantly well within the range, it's better to do that now than to wait the 3 or 4 years to just try to move a little bit up the higher end of the range, which probably after costs and expenses and time won't even be as much value in the client's pocket as that initial reasonable settlement might have been.
So yes, while we're talking about that, does it make sense to you too that the longer a case goes on, and I assume that from what you're saying, some of them do go on for quite a while, the longer someone is out of the workforce, does that not diminish what their likely salary or expected capacity is going to be? If they were making 50 and now because of the accident they're making 25, or could make 25, but they're still out of work, that 25 could easily be whittled down, and does that not undermine the case the longer it goes on? Or is that already factored in and it doesn't matter how long that case will take?
Yeah, it's something that we would factor in right at the beginning.
I see.
Because if you were making $50,000 a year and you can no longer do that job because of the injury, that's when we would hire an economist to come in and give us the calculations as to what is it your earnings. And of course, if you're earning 50 and there were some reasonable expectations of increases and all of that, that gets factored in too. Mm-hmm. So we would factor that in right at the front end, the beginning of the case.
So explain to us too then, what happens, what is the advantage or disadvantage or potential risk of you not settling, but instead going all the way to that courtroom? Could that client that you're representing actually be having a worse outcome than had they settled in the first place? So
my very first trial was an injury as a result of a young lady sledding on her next door neighbor's property. And the insurance company thought that there was no way this case was going to the jury and that we weren't going to get anything, so they offered zero. So we went to court, we went to trial. And I was able to prove through the testimony of all the other children who were there, my client, other people, that it was sledding in a danger zone because there were engine parts sticking up out of the snow and other debris, and the course that the people had set up took them around batteries and other things. And so my client, to avoid an engine block, fell off her sled and broke her leg. Went home, And the parents were having dinner, and she sat on the couch, and the next morning she was still hurting, so they took her to the emergency room, and she had a broken leg. So we go to trial, and I get to the jury. Well, I get past what's called a directed verdict. I put on my case, the defense moves for a directed verdict saying that there is no liability against us, the claim should just be thrown out. The judge says, no, I think they've proved enough, it's going to the jury. So at that point in time, they made an offer. And they made a significant offer based on the damages. So just like if that offer had been made at arbitration or after arbitration, we have that on the table. So I told my clients that I thought they really should take that offer, that it's a really good offer. And we had broken for the day. They came back the next morning and they said, you know, we've gone this far, we want to see the rest of the show. So I actually had typed up a letter at my office and brought with me, because I knew that they were on the fence about settling, saying that I had advised them to settle, because we call that a CYA letter,
Yes.
so that there's no dispute as to what I told them. And so it goes through to the defense presents its case, it goes to the jury, and the jury comes back, and the announcement of the jury is we find for the defendant. So my client's parents turned to me and said, so how much do we get? And I said, well, that would be zero. And of course, the answer is you never know what a jury's going to do. So sometimes the money on the table is worth it. Many times we've gone through the jury verdicts and gotten much more than's ever been offered. But usually I have a sense, having done this for a while, if an offer is a reasonable offer or not. And that is the very analysis that goes into whether you settle or not. What are my percentage odds of doing better with the jury than I am doing here? And once you get to a point where it's a really strong likelihood that you're not going to do better with the jury, that's when you settle. So those are the kinds of things that you have to take into consideration. In this particular case, after the verdict came back, the judge with the attorneys there would just thank the jury for their service and was actually curious as to why they found the way they did, and it was for a reason that neither I nor the defense attorney ever even considered as an issue. You didn't bring the child to the emergency room to the next day. How do we know something didn't happen between her fall off the sled and that next morning? It's sort of a silly thing, and no one would have ever anticipated that, but you don't know what a jury's thinking.
You raise a good point. From the bit that I had read in preparing for this, it seems that when you go to a jury, you could actually have the jury not like the plaintiff, might have thought they lied, didn't know completely what was going on, didn't trust expert. There was a litany of things. It certainly makes sense that you would assess the situation, and you can suggest to the client what they should do, correct?
Absolutely, that's my job. And just on the other side of that, you have to also look at the defendant, because a jury might not like the defendant, so their award may be somewhat higher than you might otherwise expect.
Thank you. We hope that this has been helpful to you in considering what might be a settlement of a personal injury case. Things for you to consider. There certainly are quite a few things for you to consider. We hope that you'll continue to stay with us in our future segments, because the law matters to you.